she called me the N-word, which I've never had that happen to me in my entire life. Everybody in Texas was really nice to me.
To talk or?
I did a quick chat with her, and she said that she could pay in July, but I'm not authorized for that.
Okay. All right. Then
so
we're going to go.
I asked to see if we could make a payment earlier, and they denied me that. So right now I would have to ask my sister again to help me, because at that time, my sister said that she would be able to help me. So I don't know, what I can do, but I do know that I have payment that should be coming in July 23rd or sooner. So then I would have been able to pay, but they want the payment within 5 days.
And Ms. Acholono, I understand the difficulties that you're going through, but what you're asking is a delay through July. I don't have any authority to grant that kind of delay. And so we're going to go ahead and move forward on this case right now.
The case opens with the tenant describing a deeply disturbing incident. She claims she was called the N-word, an experience she says she's never faced before. Despite the hostility, she recalls that everybody in Texas was really nice to her otherwise. Tension immediately builds as the emotional weight of discrimination sets the stage for the challenges ahead, showing the viewer this eviction case isn't just about money, it's about personal dignity.
There are options for you afterwards. You'll just need to speak to the landlord and the property owner with respect what those options are, or you can even, we'll deal with that in just a moment. But in the meantime, if I can have the two parties raise your right hand. Do you solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
I swear.
All right, Ms. Bowie, you may proceed.
Your Honor, this is an eviction case for non-payment of rent. The monthly rent is $14.99, and we're seeking back pay rents from March through today, June 24th, in amount of $5,696.20. A 3 days notice was given on May 5th, 2025 by posting inside the door, Your Honor. And this case was filed on June 2nd, 2025, June 2nd. And we're seeking court costs plus possession and back pay rent, Your Honor.
The tenant explains that she could only pay in July, but the court demanded payment within 5 days. She attempts to secure assistance from her sister, highlighting her financial struggle and the immediacy of the landlord's demand. The judge clarifies she has no authority to delay the payment, emphasizing the rigidity of the legal process and foreshadowing the conflict between the tenant's circumstances and the law.
All right, Ms. Ochilonu, are there any payments that you've made that you did not receive credit for, or any other credits that you believe you're entitled to that you did not receive?
Yes, Your Honor. I did actually submit payment in early March, and they denied my payment. It was for $1,500. I actually also surrendered the unit. So I made payment in March, and then they sent the payment back. The leasing manager did not want to take my payment because it wasn't the total balance of $1,655, which is just the other amenity fees and utilities. So my rent is $1,499.
Ms. Bowie, when did you show that she was given credit for that $1,500 payment in March?
I did not show because she had said they had returned it, Your Honor. The last payment she made was in February 2025 for $1,190, and that brought her balance to zero. And then
the landlord steps forward, stating the rent was $1,499 per month, and the tenant owes back rent totaling $5,696.20. The court hears about the notice served on May 5th and the formal filing from June 2nd, 2025. This clip establishes the financial stakes, showing the massive unpaid balance and the seriousness of the eviction case.
March came as $1,499, Your Honor.
So they didn't accept the payment?
Which I don't know why.
They didn't accept the payment.
Okay. So then it's not a credit that you're entitled to since they didn't accept it.
No.
Right?
No.
Okay.
Yeah. So they returned my payment. Yeah.
When did you surrender the property?
I surrendered the property on June 11th, 2025. I told them on June 4th that I would be moving out, and I surrendered the property June 11th of 2025.
And did Ms. Bowie, do you all have the keys on the property?
Have you returned the keys, Miss Casey?
Yes, I actually sent the keys on my birthday.
Hold on
from
just
New
a
York
second.
City.
Hold on. And Ms. Ochilona, is there somebody in the room with you that's talking right now?
I'm outside.
You're outside.
I don't have I'm in a coffee shop. I don't have service anywhere.
So
I can go somewhere.
Do you have headphones?
I have
The tenant reveals she submitted $1,500 in March, but the leasing office refused it, citing an incomplete balance. She explains her rent included extra amenity fees and utilities, which she couldn't cover fully. Despite her attempt to pay, the court confirms that unaccepted payments don't count as credits, highlighting the bureaucratic rigidity and her increasing frustration.
Yeah, I have headphones on.
Okay, I'm just hearing another noise. Somebody else speaking back there.
I think it's just people kind of sitting that way.
All right.
I'm sorry.
Okay.
Sorry, I can.
So, Ms. Bowie, what information do you have with respect to her surrendering the property?
I have no knowledge of that, Your Honor. So all I know is that does she have any personal belongings in there or anything? That's why she said she surrendered the keys. If they did, they would normally dismiss, she surrendered the keys. But I have no knowledge of that. So, and I'm still showing that, she's still accumulating rental fees here.
A confusion arises over the surrender of the apartment keys. The tenant claims she moved out on June 11th and tried returning the keys, but technical issues and communication barriers created uncertainty. The court questions whether the keys were ever officially received, adding suspense and showing how small administrative details can escalate an eviction case.
And she's still behind her rent when we filed made the filing, Your Honor, on June 2nd. So she was still in possession. She just left last week or so. That's why, Your Honor.
All right. Miss Ochilona, anything else that you want me to consider in your case?
Yes. So I actually sent over to them an email detailing that I had surrendered the property on the 11th and I was trying to give back keys. But the leasing manager, when I got down there to actually give the keys back, she became belligerent because I actually had to report harassment from another resident that has been ongoing since March. And I've reported it to the property managers and everything like that. And when I was trying to give my keys back,
the landlord has no confirmation that the keys were returned, while the tenant insists she left the property and cleared out her belongings. The court is left navigating conflicting narratives, illustrating the challenges in determining possession and the tension between landlord records and tenant testimony.
She became belligerent because she had found out that I had filed an incident report with the police and the security team at the property, and she called me the N-word, which I've never had that happen to me in my entire life. Everybody in Texas was really nice to me, and I couldn't give the keys back that day because I just didn't feel comfortable. My friend who actually came to move me out, he was present, and he was the one that actually ended up fixing the door handles inside of my unit. My window hadn't been fixed at all, so it's sitting there. It's been sitting there since I moved in. I did send over the keys express mail, and it arrived on the 17th. And I sent over a UPS and FedEx delivery paperwork that I had paid for to show that the keys were delivered. I also sent over an email to the regional property manager about all of the things that were occurring.
The tenant intensifies her defense, explaining that when she attempted to return her keys, the leasing manager became belligerent after learning she filed an incident report for harassment by another resident. She recounts the shocking racial abuse and how her friend had to fix the door. This clip humanizes her struggle and raises serious questions about the property management's conduct.
At the property, and when I asked them to if I could transfer over to a lower unit, because I am in AmeriCorps and I was working with the City of Austin's housing department, and we do not make enough money to live because it is a volunteer service just like the Peace Corps. And I was told by my manager, who does all of the smart housing within the city, that program, that when you are within that program, you are supposed to be making underneath a certain amount for the area minimum family income. And I make way lower than that. So originally I had requested at the beginning for that property, and the leasing manager, and it would have helped me not be in this situation, the leasing manager indicated to me that that was not possible. This is a brand new building and they were only 10% full. I have worked in property management myself, and I know that that is not the case. When an individual goes in and requests for a certain type of property.
The tenant shares that she participates in a volunteer program, similar to the Peace Corps, and earns below the minimum income for the area. She requested a lower unit to reduce her financial burden, but the leasing manager denied it. Her argument highlights her systemic financial hardship, contrasting with the landlord's rigid enforcement of rent obligations.
They should be able to see that property, although they did not show me that property and told me that I made more than the allotted amount, which, again...
So, Ms. Acholono, those are all matters that are unrelated, or I would say that are not relevant with respect to an eviction matter or forcible entry detainer matter. While you may or may not have a claim with respect to the complex on those types of issues, including, the other experience that you had to go through, that is separate from this one here today. And so I need to separate these because we need to focus on just this one here.
I understand.
I know you said that you sent the keys via mail. I don't see the information that you filed, anything that they've received it with the court.
I sent it to the court via email as an attachment. There's a photograph of it that was sent.
The judge intervenes, separating unrelated complaints from the eviction matter. Despite the tenant's attempts to introduce evidence about her challenges, the court stresses that the case is strictly about non-payment. This clip underscores how courts focus narrowly on legal facts, leaving personal grievances secondary.
Let me see.
You sent it yesterday?
I believe so. No, actually.
I mean, I see images of property. I see text screenshots.
Oh, I sent it on 9/18. Sorry, let me the date of that one. I actually sent it on June 23rd. And I also sent it twice again. And it shows that they actually have the tracking number and the shipment date. And I went and checked with UPS, and they said that it was received.
The tenant presents evidence via UPS and FedEx delivery receipts, along with emails to the regional property manager. The court reviews photographs and text screenshots, but uncertainties remain. This clip highlights the struggle to prove compliance and the difficulty of translating real-world actions into legal proof.
But I'm no longer living in the apartment, and I'm currently in New Jersey, staying with my sister for a little bit.
All right. I'm uncertain with respect to how the property was turned over, because I'm looking specifically for that, but I don't show receipt of those keys. And it's pretty common for these apartment complexes to, once property's been turned over, to dismiss if they have possession of the property. So the reason they're still here is because they don't believe that they have possession of the property yet. I'm going to find that the monthly rent is $1,499. That the past due rent is $5,696.20. The appeal bond will be set at $3,000. Ms. Ocholono, what you can do
Your
is,
Honor?
Ms. Ocholono.
Your Your
What
Honor.
you can do is you can appeal my decision.
The judge rules that the tenant owes $5,696.20 in back rent. An appeal bond is set at $3,000, with instructions for filing and paying or requesting a hearing of indigency. This clip conveys the legal finality of the court's decision, while still leaving room for potential resolution through appeal.
Okay. The court clerks will give you the information that you will need. And when I say information, I'm talking about the paperwork, but it's blank paperwork. You still need to fill it out. There are different options with respect to the appeal bond. You can either pay that appeal bond or you can file an affidavit of indigency, and then a hearing will be held on that to determine whether or not you can afford to post that bond or not. Once that's done, you can then, in order to appeal the decision, you can continue paying the rent in cash to the registry of the court. And in doing so, that'll keep this case on appeal. It'll keep it open. But once you stop doing that, then of course the appeal is dropped at that point in time. You can always speak with the property to try and reach some type of resolution, to try and get all of this matter resolved, and that can be done post-judgment.
The tenant insists she already moved out and submitted evidence proving the apartment was empty. The court acknowledges her documentation but remains bound by presented evidence. Viewers feel the tension as the tenant's perspective clashes with procedural limitations.